for time, 3 days, to file our written submissions with regards to that application of the 18th.
We are actually the ones to start because we've not filed.
So I'm not. The next step is now to give directions. Yes. Are you through with the?
I think that's
issues?
Yes, that's okay. Yes. I hear him say that he prefers to proceed with the application of the 18th on our part.
Yes.
We were cognizant of the court's time, and we thought that it might be better for the record for us to argue all the issues that have been raised together.
So the two applications be had together?
To be had together, rather than us coming before you arguing the 18th, the application of the 18th. Yes. And then 2 weeks later, we come back to you adding the application of the 14th, because they're really quite tied together.
Yes.
But it would be illogical for the simple reason that if you say you are relying on this set of petition of appeal, grounds of appeal, and those grounds have not been admitted, then you cannot be able to argue for bail, referring to them as if they have been admitted. That question has to be resolved first. Because now we don't want to be dealt with in a mud or rough situation where we don't even know what are we basing our applications on. So it is also occupational hazard that if it requires us to come twice, we shall need to come twice because of the logic of the situation. It is not possible to say that you are arguing them together and we've not admitted those grounds.
Can you seek leave to appeal and at the same time seek leave, stay in execution?
Leave to appeal. Melody, that's why we are saying.
No, I just want us to understand whether we can handle the two together.
We cannot handle them together because the applications for bail is premised on grounds of appeal that ought to be admitted. Because our right to refer to them is based on admission.
But you have sought leave for them to be deemed as filed.
Yes, but we have not been given leave. It's just like even an amendment in civil procedure. If you want to seek an injunction and there is opposition to an amended plaint where the injunction is sought, you'll have to deal with that issue first of the amendment. So it's actually them who are complicating a small issue.
No, I thought we were trying to save time, but...
No, that saving time throws us into a serious matter of logic, which I don't think we can just go into.
I agree.
Yes.
So then we need your application, which is the March.
Yes.
But Your Honor, my lady, perhaps in the...
Yes,
Yes, my lady, perhaps in the interest of saving the time that the respondents are conceding to, how about if the court considered on its own motion, but all what we are here for is for seeking of leave? Why should we consume court's precious time when the court itself can swim more to make a determination whether a right to amend can be denied? So that, Your Ladyship, then we are saying that we'll be then in sync with the respondents, that we are all saving time, because we shall only be urging the question of leave. And the court can, on its own motion, exercise that discretion.
But your application for leave is opposed. You have to be an... Yes. You see, this is not an issue I can exercise my discretion. Because the application for leave is opposed. They have grounds of accusation and it's a preliminary objection.
I agree with you, but my lady, if I recall when the last time you were here before you, what was in contention was the manner in which our amendment was worded.
Yeah.
So the contention then that day was, should it be a supplementary petition of appeal or should it be an amended?
Yeah.
That's what the only bone of contention. And therefore, if you have brought before you a document that is correctly worded, then I think then perhaps logically it would mean that the same would not be contentious.
You see, as long as there are grounds of opposition, what does that mean? The application is opposed.
We'll take your ground.
Unless it is by consent, then I have to hear all the parties and I have to make a ruling. Because this is leave to amend, isn't it? And it is not automatic.
We'll take your elections.
It is not automatic, and I believe that is why it is opposed. And therefore, we have to hear the application.
Much obliged.
Yes. So therefore, I've marked your pair 2 of the application dated 14th of March 2025 as abandoned.
Yes.
So now I'm giving directions, and you have asked the court we can proceed and first hear the application dated 18th of March.
March, yes.